This is Ann Zilke, parent trainer for Wisconsin Facets and the moderator for today's webinar. On behalf of everyone at Wisconsin Facets, I would like to thank you for joining us today for our webinar entitled Guardianship and the Alternatives to Guardianship, Supported Decision Making. Our presenters today are Vicki Davis-Davila and Tami Jackson. It gives me great pleasure to introduce to you today Vicki Davis-Davila and Tami Jackson. Vicki, go ahead and take it away.
Thanks, Ann. So my name is Vicki Davis-Davila. I'm an attorney specializing in disability law. I've been practicing for about 10 years, and my practice covers people with disabilities across the lifespan, from birth all the way up to elder law. And it does include quite hefty amount of guardianship and decision making. And I'll let Tami do a quick introduction of herself as well.
Hello, I'm Tami Jackson. I am the policy person and the legislative liaison for the Wisconsin Board for People with Developmental Disabilities, and was worked on the passage of Wisconsin's supported decision-making legislation.
Thanks, Tami. So we'd just like to start out with some kind of groundwork about decision making and how it affects people with disabilities. Ableism and cultural bias causes some people to assume that people with any type of disability are incompetent. This manifests sometimes in families or caregivers not giving young people with disabilities the same opportunities to experiment, branch out, and learn life lessons. Professionals leaning on or straight up relying on parents or caregivers to make decisions on behalf of the person. And that can cause people with disabilities to feel helpless, like they don't have control over their own life, that they don't have the opportunity to get these life experiences. So making sure that from a young age, we are focusing on agency and autonomy and letting people with disabilities make and communicate their own decisions to the greatest extent possible is crucial. A lot of times I get asked, when should we start thinking about what decision-making options are going to work for my young person? Definitely transition planning through the IEP process. So starting at age 14, not that you can't start before that, but at that point, the whole team of people working with the person and the person themselves should think about how are you transitioning to adulthood? What kind of education and training and support can we provide to you to help prepare you for that 18th birthday? If you have concerns about capacity, starting around age 17, you can talk to your child's doctor or psychologist. Powers of attorney and supported decision-making agreements can be executed at age 18. Guardianship can actually be done a little bit sooner than that at 17 and 9 months. But what happens at age 18? This happens for everybody, regardless of what their diagnoses are, regardless of whether or not they have an IEP, who they see for a doctor. If nothing else intervenes, an 18-year-old makes decisions about continuing their education, consenting to medical treatment. They can sign contracts, apply for licenses, loans, credit cards, any rental agreements, housing agreements, any type of things like that. An 18-year-old at the 18th birthday gets the ability to do those things for themselves unless one of these other options is in play. Another important concept of our discussion today is what is an informed decision. So there are components to that. First, you need to be able to understand the inputs, the information you're getting in order to make the decision. You need to be able to at least somewhat explain what are the consequences, what are the possible outcomes of making this decision, have a method of expressing it, however that may be, whatever works for you. But it does not mean a perfect decision every time or the first time. I don't think most people made perfect decisions every time or the first time at age 18, and people who may have a disability are no different. So today we're going to talk about options for decision making kind of existing along a spectrum. Informal options include things that can be done pretty quickly and easily without attorney involvement. An example would be signing a release authorization, so a parent could continue communicating with a school or with a medical provider. More formal than that, but still very flexible, are the supported decision-making agreements that Tami is gonna talk to you more about. It is a legal agreement, but it still gives the person a lot of power and control over and direction over their own life. Powers of attorney are they're here on the spectrum because if they're activated, they are more restrictive than some of the informal options and supported decision making, but they're also something we'll discuss that can exist in the background. And then finally, guardianship, even limited guardianship, is the most restrictive option, and we will get into that as well. So now Tami is going to talk to you in more detail about supported decision making and how it can be used to help you or your family.
And Victoria, could I ask you, you're on it, you're advancing the slides.
I'm on it.
So I would like to ground us in the idea of what is supported decision making. And the reality is that myself, Victoria, all of you use supported decision making in your own lives all of the time. Whenever you're thinking about a decision, and I will use a recent silly example from my life. I needed to buy an immersion blender as a gift, and I crowdsourced people I knew, my friends of mine, and asked for some advice on what should I be looking for? What are features that are important or not important? And I drew on their experiences, and then I made a decision, and I got my immersion blender. Supported decision making is that process of consulting with a network of people who you know and trust, considering the information that they are providing, that they are giving you, and then making your own decision. And we do it all the time. Everybody has the ability to make choices, and we all ask for some varying degree of help, and we don't need to give up our rights, our civil rights, to make those choices. And in fact, all of us often need help in understanding and making and maybe even communicating our choices to other people. So that's kind of what supported decision making, is in the nuts and bolts sense. It's something we're all very familiar with. We have a law in Wisconsin because, as Victoria shared on an earlier slide, even though Wisconsin law presumes everyone is legally competent at age 18, our cultural biases make us believe erroneously that certain kinds of people, older adults, people with mental health issues, people with intellectual developmental disabilities, we presume they're not competent. And supported decision-making agreements are really a way for folks to assert that they are making a decider and are in control of their own decisions. Next slide. So who can use agreements in Wisconsin? The law says that anybody with a functional impairment can use a supported decision-making agreement. We presume that if you self-identify and say, yes, I have a functional impairment that meets the categories in the law, you have one and you can use an agreement. So you don't need to get proof or a doctor's note or somehow ask permission to use these agreements if you are self-declaring that you have a functional impairment. And you can see the list here of who what are functional impairments in the statutes. Folks with degenerative diseases or other conditions that interfere with self-care or limit activities, physical disabilities, mental health conditions, intellectual and developmental disabilities. And you'll notice that we have of any age in here because things happen to people all the time. So the law is really designed to include as big a swath of people as possible. Next. So supported decision-making agreements do not give the supporter, and we'll talk about what the role of a supporter might be, any new rights. The person who is always in control of their own supported decision-making agreement and of their own decisions. Sometimes you might consult a network of folks and they will tell you information and you may make a decision that one of the people you consulted with does not agree with. That is part of life, and you are certainly able to do that with a supported decision-making agreement. The person is always the decider. And the supporter really has no authority to make the person's decisions for them because the person is always the decider. We'll talk about what the role of a supporter is next. Next. So a supporter identified in a supported decision-making agreement really has 4 possible roles under the statute. They can help gather information, only information that's relevant to the decision that they're being asked to help with. But they can help gather information. They can help the person understand that information. And they can help people understand what are the options and responsibilities and consequences of their decision. It's not making the decision on behalf of the person. That's kind of saying, okay, you have here option A, B, or C, and here are the pros and cons of each, like we would do with our own network of friends and family. And the 4th piece is communication the person's decisions to others. And I have to confess to you all, I really did not appreciate how important that last piece is. For many people, especially that happens to be the thing that they want the most. When you think about an older person who maybe is hard of hearing, they don't need, all of the other things, but what they do need is somebody to hear and communicate for them. Same with some of my friends who have cerebral palsy that has impacted speech. So this is a really important role. Next. You can have more than one supported decision-making agreement. As you might think about your own life, there are probably a network of people that you know who have different areas of expertise, and you might not ask the same person in your life for advice on how to file your taxes as to find an apartment or which internet service provider to provide. Supported decision-making agreements are really trying to reflect people's real lives. So we want to make sure that they are flexible enough that people can really tailor their agreement, not only for a role or one of those 4 roles that they might need, but to specific decisions. Because that's a big advantage. When we were passing this law, we had a family member who used to say, you know, I am the only person who is willing to be a guardian for my son. I can't think of a single other person who would want to take on all of the decision making and responsibility and role of a guardian, but I can think of half a dozen people who are willing to help him on a little piece that they feel comfortable with. And for him, that was a really big deal for supported decision making agreements, is that it really spread the ability to use a wider network of people to support his son. Next. Again, the person is in control of their agreement, so they're always the decider, and they can decide how they want to structure this agreement. A specific date can be used to end the agreement. We always tell people, you know, once you have a document in place, you should revisit it, you know, and make sure that it's still working. Does it need to be, you know, changed to reflect more experience making those decisions? Maybe you need more or less support, and you can revise that agreement at any time. The person or the supporter can revoke a supported decision-making agreement at any time. And that's important because sometimes things in a supporter's life change too. And so the level of support that they may be able to provide may shift and change. These agreements are meant to be living, breathing, evolving documents that reflect how people's lives really change over time. They're not a moment in time decision. They are intended to be something that grows with the person. Obviously, there are protections in the law when an agreement is automatically revoked, and you can see that in the 4th bullet there. You can't serve as a supporter if you are abusing or neglecting the person, or have a restraining order against you, those types of things. But again, supporters don't have any authority to make the person's decisions for them. So that's an important thing to remember as well. Next. There are other changes that the legislation made. I think the one I would point out to this group is that there are liability protections in there for professionals. This is, as Victoria said, it is a legal document, just as a power of attorney is a legal document and a guardianship order is a legal document. And professionals should understand that when they receive this agreement, it does have the force of law, and that they can rely on it as an expression of the person's wishes and an expression of, here is who the supporter is and here is what their role is. Next slide.
Tami,
Yeah.
do you find that sometimes people have a little trouble getting professionals, I guess, to recognize and honor the supported decision-making agreement?
I think that with anything that is relatively new, supported decision-making agreements became law in 2018. It takes a lot of time before professionals recognize those agreements. And I would say, I don't know if your opinion is the same, Victoria, but I think that there are many professionals who don't necessarily see the legal distinctions between a guardianship order or limited guardianship or powers of attorney or other types of papers. So there's certainly a need for continuing education, to help professionals understand how these different documents, what they mean, and I do think that we have professionals who have seen a lot of these and understand what they are, and I think we see professionals who would prefer to interact with somebody other than the person in front of them and are looking for a way to do that.
Yeah, and I agree, and it's true with any decision-making vehicle. there may be an educational component for you as either as the supporter or whatever role you're in. And the BPDD has excellent resources to help people really understand their role and how to direct people, I think, to understand what supported decision-making agreements are and how to use them, which is where we are now.
Right. So the great flexibility for supported decision-making agreements is that they really can be used for any decisions where somebody needs help. Supported decision-making agreements are one alternative to guardianship. Powers of attorney of either healthcare or finance are in conservatorship or some others. But this is really pretty flexible in the sense that, you know, if you have a decision to make that falls outside of healthcare or finances, you can use one of these and it will work. We've already kind of talked about flexibility, but I think it's a really important point to underscore that, you know, as people age throughout their lives, their capability and experience making decisions increases and changes. And so these agreements may start with a level of support when somebody is 17 and a half, or well, 18, and maybe that support level is very different at 20 or 25. The agreement can be adjusted to reflect that learning. Next. The form for is actually outlined in the statute, and there are certain things that are always included in the agreement. I won't read them all here, but I think the thing we get most questions about is, well, how do you make it legal? And that's really the last bullet here. To make a supported decision-making agreement a legal agreement, you need the signature of the supporter or supporters, and the supporter must be over age 18, 2 witnesses who are over age 18, or a notary public. So that's what you need to have a legal, valid, supported decision-making agreement. Next. On the form, there are certain kinds of decisions that are itemized, but the reason why agreements are so flexible is really the last bullet that's on this slide. So you can check if you want help on the things that are kind of pre-populated on the form, but other decisions that you identify, that's what really makes supported decision makings open to any other things that somebody might want to have a little support with. Next. We do presume, the law presumes that if you don't check yes or no, I want help with the decision, then you don't want the supporter to help with that kind of decision. Again, the whole idea behind supported decision-making agreements is the person is really making decisions and in charge of their life. So we presume that they are telling us what they affirmatively want help with and what they want, who they want that help from, and what they want that person to do. Next. All right, so what are some of the benefits and other benefits and advantages of using supported decision-making agreements? I worked with an aging advocate on this legislation, and she would often tell me that many of the older women that she worked with, sometimes their closest relationships were with female friends. People who they had no blood relationship with, maybe they had never had children, or their husbands had died, or their children were in different geographical locations across the country. The people who knew them the best and had daily interaction with them in their lives were folks that were family members. And supported decision-making agreements ensure that people who are not first order relatives can still act as supporters, and that a professional that receives the agreement can go, oh, here's who you are and why you're here. And it is important that we recognize and try and build a wider network of people that know and have eyes and ears and understand the people that we care about, because the more context that they have and the more places there are to go for support, the safer folks are. Next. We've talked about this a little bit before. You know, all of us experience changes, and sometimes we get better at stuff, and sometimes our capability to do things declines. For a lot of people, as they age, they may need a little bit of help for a really long time. And a supported decision-making agreement, the flexibility allows you to add increasing amount of help without necessarily taking a step to remove somebody's civil rights to make their own decisions. The picture here is of an older couple. You know, a lot of folks who are getting diagnosed with dementia in their 60s, maybe they will need a guardianship at some point, but they might not need it for 20 years. And this is the type of thing that can be a bridge as you're transitioning to a place where maybe you do need a different solution, and it might be guardianship at the end of it. Next. For obviously the organization I work with works with many people with intellectual and developmental disabilities. That's the population we serve. So some of these examples are places where parents and family members of kids with intellectual and developmental disabilities are using these agreements. Some of these may be familiar to you as well, and certainly, you know, they're all very much acceptable places where you might use this type of agreement. Next. The other benefit to using supported decision-making agreements, again, that communication piece that I said I underestimated the value of when we passed the law. There are a lot of folks that really have great competency. They're very clear about what they want, and what they need is somebody to help translate their communication to other people who may not be as familiar with them, with that communication style or understand. We talk to a lot of people who have folks who are nonverbal, or maybe have speech impediments, or maybe there's there is a delay in their ability to respond and talk. All of these are folks who may not have any issue with making decisions, but it's critically important that they be understood by people who are not familiar with them or their communication style. And that is a role that a supporter can play. Next. Conversely, I always tell people never go to a doctor appointment alone, and I kind of laugh, but I'm also serious. There's also real value in having a second set of ears in the room as a supporter who's able to kind of translate. It's that translator role from professional to the person. A lot of the people with intellectual and developmental disabilities, they have no trouble understanding as long as things are explained in terms that they understand. And that sounds like a silly statement, but the reality is that a lot of times professionals might use acronyms or use language that's unfamiliar, or do not know the person well enough to know how to explain a concept in terms that the person can relate to. These are all things that a supporter can do that can be very, very helpful to making sure that the professional is understood by the person and that the person is understood by the professional. Next. Next. So we have, not all of you are professionals on this webinar, but we left this in here. This is one example of a sheet that we have in our toolkit for the person who has the agreement, and it's intended to be something that they can hand to a professional that really outlines you know, it's kind of an assertive document that says, I have a supported decision-making agreement and I'm the decider. But we include this in the presentation because I think this is the kind of message that a lot of professionals, you know, need to understand, that they are interacting and engaging with the person in front of them and not the people around them. And that person in front of them is in fact able and capable and wants to be making their own decisions about their lives. Next. For those of you who are professionals, you know, as I said, supported decision-making is relatively new, 2018. Guardianship has been around the longest. Powers of attorney came in, I believe, in 2008, and maybe 2010. They're two different types. Victoria will correct me. You know, so it takes a long time sometimes for systems to kind of update themselves and make sure that they are current with the law. So we certainly have run into parents who have said, you know, the professional I'm interacting with, there's a drop-down menu in the file where they can say I'm a guardian, but there aren't drop-downs that denote whether I'm a power of attorney or a supporter. And these are things that you should be asking. And if you're a family member, you know, whatever documents you have, you want to make sure that the people you're interacting with know what they are and have them on file. So if you're in a position to look at your own organization and say, okay, how are we incorporating this new legal option into our forms, into how we think about clients, then do that. And if you're the family, you know, you may need to ask. Again, these are general communication tips that are good to use with any person at all, but especially with people with intellectual and developmental disabilities. And we think that part of the reason why folks end up having people making decisions or talking around them is that they're not doing some of these things. They're not allowing space to hear and allow decisions to be made. Next. Next. Here is a link to the official supported decision-making agreement form, which is housed on the Department of Health Services website. You can download this and fill it out. You do not need to get an attorney to do so. You do not need to go to court. There is no fee. It is a free option for people to use. Next. And here's a link to the toolkit that we put together, which is intended to be used by people who might be executing their own supported decision-making agreement and families, and a link to the actual statute, because I'm a big believer in recreational reading of statutes. I know everybody on this webinar probably does that in their free time. Next.
That's it for the supported decision-making slides. So in the interest of time, I'm going to move a little bit quickly or more quickly through powers of attorney. Just generally, in making a determination about whether a power of attorney is appropriate or not, some questions to ask is, does the person want help? Are they willing to accept help? Are they willing to share some decision-making power? And I think the most important question is, does the person understand the concept of a power of attorney? It is a pretty massive transfer of power into the hands of another person, and can result in some excuse me, major decisions being made. And here's a big difference between this and SDM, being made for someone. So it's really important that a person, not that they can recite the statutes or give a lawyer's definition of what it is, but that they do understand they're transferring power. There are two types of financial or of powers of attorney. One is financial, one is healthcare. Oftentimes, financial powers of attorney are effective immediately. They don't have to be. They are either permanent until death or until they're revoked, or they can also have an expiration date. It allows another person to manage finances and property, but also certain contracting and decision making, even digital property, so access to your your online life. It's completely voluntary. It can be rescinded at any time. With either kind of power of attorney, the creator is called the principal. The person who's receiving power is called the agent. For financial power of attorney, we want the person to be able to choose who they want their agent to be, understand their income and assets, and again, understand the powers they're transferring. For a healthcare power of attorney, this gives the transfer of healthcare decisions to the agent. In order to do one, you need to be at least 18 years old, and the statute says of sound mind. It doesn't tell us what sound mind means, except it means no finding of incompetence. So that means if you have a guardianship, you cannot subsequently or after you've been put under guardianship do a healthcare power of attorney. If you have one already in effect, that's a different story. So that's one of the many things affected by guardianship. Generally, not all the time, it can be drafted differently. A healthcare power of attorney becomes effective if two physicians or one physician and one advanced practice clinician. So, and that recently changed in the law to use the term advanced practice clinician. So it's expanded the window of people who can activate it. They have to personally examine the principal and sign a statement saying that they have incapacity to make their own healthcare decisions. And mere eccentricity, old age, or a physical disability, either separately or together, don't make someone incapacitated. And if a person does not have incapacity, then their desires always override the healthcare power of attorney at all times. So perhaps you've directed certain things in your healthcare power of attorney, but at the time you're being asked, you don't have incapacity and you're saying something different, your wishes override what you have in your document as long as you still have capacity. Powers of attorney are not just for people who might have a disability, might have a degenerative brain condition, that think they might need an alternate decision maker at some point. Every single person on this call, everybody you know who's over 18 should have powers of attorney, both healthcare and financial. It's something that for most people exists in the background, but it allows our friends and or family, spouse, whatever the case may be, to help us in the event that we are unable to make our own decisions, either permanently or temporarily. And powers of attorney can coexist with supported decision-making agreements very well. So I want to use the time that I have to talk about guardianship, and I am moving quickly because I want to make sure we have time for some questions. Before I start out, you know, we said in the beginning, guardianship is the most restrictive form of substitute decision making. There is court oversight. It necessarily affects a person's fundamental civil rights, things that make us citizens, things that make us people are affected by guardianship. And it's really crucial that it's only used when necessary, and when it is used, that it's tailored to be the least restrictive form of guardianship necessary to to protect the persons, their health, and their finances. Unfortunately, that's not usually what happens. The court is supposed to consider whether least restrictive options have been tried and failed, whether a supported decision-making agreement might be appropriate. But oftentimes, and I think it goes back to the first slide about ableism, that's not the case. So I'm sure we have a lot of parents and caregivers on here, as well as supporters and professionals. And I think we can really change the narrative of not presuming that guardianship is the only option or the best option. But sometimes it is it is a necessary evil, I'll say. A person must be at least 17 and 9 months when the guardianship is entered. So that would be the day that you have your hearing in court. You can't file it before the person is 17 and a half. And the person's need for assistance in decision-making or communication cannot be met effectively and less restrictively through appropriate and reasonably available training, education, support services, healthcare, assistive technology, or other means that the individual will accept. And I broke that down into bullets because all of these things should be assessed individually. So for example, you could have a person who assistive technology and support services might help, but if they're unwilling to accept that and are in some type of danger because of that, then you might be in a guardianship situation. Guardianship is broken down into 2 areas, just like powers of attorney. I'm going to spend more time talking about guardianship of the person. It is somewhat, but not totally, similar to the healthcare power of attorney because it's about health and personal decisions, but this is also where the important civil rights are affected. It is court-ordered guardianship of the person. They do exercise some rights and make important decisions on behalf of the person under guardianship, which is called the ward. Guardianship of the person does not grant the ability to make financial decisions. So some key terms here, the petitioner is the person who is asking for guardianship. That may be a parent or another family member. In a lot of cases, it's the county through their Adult Protective Services Department, but really anyone can ask for guardianship on behalf of someone else. The proposed guardian is the one who would be the decision maker, and the proposed ward is the person who is under guardianship. There needs to be evidence in order for a court to grant a guardianship. I've attached as one of my handouts the form called the Examining Physicians or Psychologist Report. Any doctor or any clinical psychologist can examine the ward. There is a statement of rights that is required to be read to the individual prior to the examination, so they understand the purpose, what this examination is for, and that it basically would be used against them in court. And the form is, it's only about 5 pages long. It ends up being a little longer when it's all filled out, but it answers questions about the person's conditions, what their needs are, whether they meet the standards for guardianship, whether the evaluator thinks they need a protective placement, which is when the court says you need to live in a certain type of facility. And it also addresses each of the rights that are affected by guardianship. The legal standard is that because of an impairment, the individual is unable to receive or evaluate information or to make or communicate decisions to such an extent that the individual cannot meet the essential requirements of their health and safety. So this is, I think this is important to consider too. Essential requirements of health and safety are not simple bad decisions that young people make that aren't affecting, like not taking medication, not taking medical care, extreme self-neglect, putting yourself in dangerous situations. Those are the kind of things, that and being unable to make basic needs is why we might be thinking about guardianship, not necessarily because the person doesn't follow household rules or spends all their money on fast food, or some of these smaller things that, while not good decisions, aren't dangerous or unhealthy decisions. Impairment in the guardianship context, as opposed to supported decision-making agreements, which have a very broad umbrella of who can use them. Guardianship has only 4 categories of impairment, which are developmental disabilities, serious and persistent mental illness, degenerative brain disorders like Alzheimer's or dementia, and then there's a 4th catch-all category, other like incapacities. An example of something that might fall in this category is a traumatic brain injury. Many guardianships are used for the elderly and people who are suffering from Alzheimer's or dementia. However, there is no age limit. It's used for 18-year-olds and people about to turn 18 all the time. There are 3 kinds of rights, or 3 categories, I guess I would say, of rights. In terms of their relationship to the ward. There are some that are removed in full. If those are removed, the ward can't exercise those rights, but no one else can do them on their behalf. Then there's another set that can either be removed fully or executed with consent of the guardian. So basically, if they're retained partially, the ward can do it if the guardian says it's okay. And then finally, there's a large bank of rights that may be transferred to the guardian, either fully or partially. And we will go into more detail on those. So as I was saying earlier about important civil rights, 3 rights that may be removed fully are the right to serve on a jury, to execute a will, and to register to vote or vote in an election. I do want to mention that Disability Rights Wisconsin has been actively working on programming and education to help people under guardianship restore their right to vote. The right to vote is removed pretty uniformly for people under guardianship. However, there is research and evidence to suggest that it's improperly removed in many cases because people actually, though they may need a guardian for other reasons, absolutely have the evaluative capacity to vote. So especially for people who are transitioning, and when you're in these IEPs and talking about transition, if you're concerned that your young person doesn't have capacity to vote, I feel like this is such an important time to be discussing what can we work on about the elective process? What can we do to help teach and do education, training, and support so when the 18th birthday comes around, we don't have these reservations, and also making sure that the person and their supporters understand that there is basically unlimited support if necessary to actually execute their vote. If they need somebody with them at the polls, whatever the case may be. So things that we may perceive as limitations may not actually be so. And Disability Rights Wisconsin is doing an excellent job getting the word out on restoring the right to vote. But as we're going forward, let's just not remove it if it's not appropriate. The next set of rights that can be removed fully or exercised with consent are sterilization, marriage, donating body parts, and applying for licenses. Marriage is a huge one, and it can be removed, which means you don't have the right to marry even if your guardian says it's okay. But it doesn't mean the guardian can force you to get married. Any of these, force you to donate organs, force you to get sterilization. If that right is retained with guardian consent, the person can do that thing as long as the guardian consents to it. Obviously, these are very important rights. Sterilization, people always ask me why that's in there. It's because people with disabilities were being forcibly sterilized within, certainly within my lifetime, probably within the lifetime of most people on this call. Driver's license, professional licenses that you might need, for example, to be in all kinds of professions, barbers, hairstylists, certain building trades require a license. My job, many jobs, that would affect your ability to do that. Hunting and fishing as well. Big important things to many families and people in Wisconsin, and that can be affected by guardianship. And then finally, there is a bank of rights that can be transferred from the person and their ability to make their own decision, either fully or partially. They don't have to be. And we were talking before about, checking boxes. If boxes aren't checked here, person retains the right and they make their own decision. The guardian would have no authority. But oftentimes, these powers are transferred either in whole or in part. Those include healthcare decisions such as treatment providers, what the treatment would be, including medication, releasing your confidential health information, and there are even specific things about experimental treatment or research. It does not give the guardian the ability to force someone to take certain kinds of psychotropic medications. That is a separate court order, and that's a myth, I think, about guardianship. It also covers social services, educational decisions, work, protective placement, which I mentioned earlier, whether or not the person can get divorced, advocating for the person in court, receiving notices, mobility and travel, where you go, when, and with who. It's covering all aspects of a person's life. I mentioned in the spectrum full versus limited guardianship. In some other states, it's called a plenary guardianship, where the guardian has every single right that exists transferred to them, and every right that can be removed from the person is. A limited guardianship is anything short of that. The person may retain some rights. There may be very specific guidance in terms of how the person's input is to be considered on certain types of decisions. So a well-tailored doctor's report or psychologist's report can result in a less restrictive limited guardianship, can result. Some of the reasons, just to hammer in like why this is the most restrictive option. Number one, it's permanent. It lasts until the person passes away. You may change guardians in that time, but unless you go back to court to modify or terminate the guardianship, it is there. And changing it requires, you know, presenting evidence to the court that we granted this before. What has changed since then that this person no longer needs it or suddenly can exercise these rights? We've talked about the effect on a person's civil rights. I have unlimited scope and limited scope. So in some ways, there are things that it doesn't cover. It doesn't address things in the guardianship order, like a person's freedom of speech or association or religion. But in practically speaking, all of these things can be curtailed with a guardianship. If a person doesn't have the choice to live where they want, go to church where they want, see who they want to see, there are many things that that can be affected, and due to, you know, ambiguity in the law, cultural biases, whatever, some of these things go unchecked. And then lack of true oversight. So for a standard guardianship, a person has to file an annual report on the ward. The guardian has to file that. It's a one-page check the box form that basically says, where is the person? Has their condition changed? How often do you see them? And it really doesn't give a whole lot of more about how they're doing. It's coming from the guardian and not the ward. Nobody is going, you know, to check on them to see how they're doing. So if they have advocates, if they have people in their corner, if they can advocate for themselves and find their own lawyer and put their own case on, and you know, it's hard for anyone to do that, then that oversight is there. But practically speaking, it's hard for a lot of people to access that. So I think we are we started a little late and we're getting to the end of our time. I'll just quickly say that there is an interplay between tools. Any combination of these tools can be used together. Families who come to me for supported decision-making agreements, I always recommend that they do powers of attorney as well for the person, you know, for the creator of the supported decision-making agreement, and for the parents as well. Guardianship can come into play with powers of attorney and it be limited to only what's not already covered by the powers of attorney, etc. Informal options can be interspersed with all of these things. And like anything else, it's good to know all the tools in the toolbox and you know, find the combination that works best for you or for your loved one to make sure their needs are being met. I have some resources. Marquette Volunteer Legal Clinic. Yes, they are physically in Milwaukee, but they also have a mobile legal clinic. One of the silver linings of COVID is, you know, the expansion of online legal services, which is great. I also have some information about guardianship, supported decision-making, and like supported decision-making agreements, the advanced directives, meaning powers of attorney and living wills, are available online through the state of Wisconsin. You can print those out, do them yourself. So that's another good resource. So for those of us who are still with us, I don't know, Facets folks, if we have time for questions.
Sure, I think we're running just a little bit over. I'm so grateful for both of your presentations. It was such a great amount of information. So I'm thinking what we'll do is just ask you both if you have any sort of closing thoughts for everyone.
I can go first. I think that just starting these conversations early, like I said, it's transition time with the IEP, start talking about, you know, what do we need to do to have a good decision maker? And those are questions that any parent or caregiver should ask for their child. And how do we act in the least restrictive way possible? And what can we do to use some of the less restrictive options and see if we can find a way to have that work for our loved one. It takes a village and it takes early planning, but knowing your options and knowing that it can be done and that your loved one can be safe and have all their needs met, I think gives everybody a peace of mind if you plan early and really explore all your options. Tami?
I guess I'll just capstone it by, this is really a conversation about future planning, and future planning conversations are hard because they require families to really knuckle down and go into some uncomfortable space. None of us know what our world is going to look like in 5 years, 10 years, 20 years, 50 years. And I think there are a lot of things that are available that are informal, like even, limits on bank accounts and other things that, when families start thinking about, okay, what is it that we really see as a need for help, you can start thinking about what kind of things can we put in place. And some of those things might be informal. Some of them might be alternatives to guardianship, like supported decision-making agreements or powers of attorney. And maybe you might end up with going down a path to guardianship. But it's really important to think about the whole context of your life and your person as it is now, and then try to envision what it might be in the future. Every presentation I do, I have somebody who's a guardian who's 70 or 80 years old who doesn't realize that someone else will be the guardian, and it may be somebody that their ward doesn't know. And these are things that are serious consequences. As Victoria said, the guardianships are not easy to be changed. So you can get to that point, but you don't need to start there.
Thank you both so much. We just have one quick question, and maybe either of you could answer. Where would a family find the guardianship paperwork?
Sure. The link is long and convoluted, but if you go to wicourts.gov, there's a form section, and then guardianship has its own a link, its own category of forms, and everything you need, not only to start it, but to change it and all that, it's all in one place there. wicourts.gov. I can type that in the chat box.
Wonderful, thank you so much. This concludes our webinar. On behalf of Wisconsin Facets, I would once again like to thank you for joining us. And thank you again to our wonderful presenters, Vicki Davis-Davila and Tami Jackson. Please take a moment to fill out the brief evaluation. We really need your input in continuing to provide quality trainings. Have a wonderful rest of the day.